The Michigan Supreme Court is taking on a case involving a controversial practice carried out by Grand Rapids police. The case involves two black teenagers who were photographed and fingerprinted by police, but never charged with a crime.
News 8's Jacqueline Francis spent the day digging into this case, and she joins us live now from Grand Rapids with what she's learned. Jacqueline.
Brian and Sue, this all started about 10 years ago when a black teenager was stopped by Grand Rapids police while walking home from school. He was never arrested or charged with a crime, but the teen's photo and fingerprints were taken right here on the side of the road. It wasn't the first time something like this had happened, as the practice will soon be reviewed by the state's highest court.
After years of being shut down in the courtroom, the Michigan Supreme Court is giving new life to a nearly decade-old case. It has to do with two black teenagers who were photographed and fingerprinted by Grand Rapids police, but never charged with a crime.
These were two teenagers, 15 and 16 years old, who were just walking on the sidewalk. And they were stopped by the police.
The two separate incidents took place in 2011 and 2012. Since then, the ACLU of Michigan has taken on the case, claiming the teens' constitutional rights were violated.
They're completely innocent, and yet their information, private, personal, unique information to them, is now in a police database and is stored by the police forever.
The lawsuits were first filed in 2014, but never made it before a jury. The judge ruling in both cases that the officers' actions were legal. Despite their victory in the courtroom, GRPD changed its policy a year later, drastically reducing, but not eliminating, the practice of taking photos and fingerprints of someone without identification, also known as P&P. However, the ACLU wasn't satisfied with the change.
The P&Ps should just be sent to the dustbin of history. This is a failed policy. It hasn't made people in Grand Rapids any safer, and it's been violating the constitutional rights of people, especially young people and especially people of color, for decades.
In addition to arguing the policy is a violation of the Fourth Amendment, the ACLU claims the practice also encourages racial profiling, submitting data to the High Court after reviewing all P&P stops carried out by GRPD between 2011 and 2012.
The racial disparities are truly shocking. The vast majority of individuals who had their fingerprints and photographs taken under this policy were black, even though black people make up a minority of the population in Grand Rapids.
Although their argument didn't prevail in the lower courts, the defense claims the legal framework surrounding the Fourth Amendment, which defines reasonable search and seizure, has evolved in recent years.
So I think one of the reasons the Supreme Court took it on is they realized that the lower courts hadn't really been using the most up-to-date law, and we expect that they will apply the most up-to-date law in this case when they hear it in the next few weeks.
The Michigan Supreme Court is scheduled to hear this case on November 9th. In the meantime, we reached out to the Grand Rapids Police Department, who declined comment, saying they expect to release a statement on the matter later this week. I also asked the department for more recent numbers when it comes to P&P stops since they made that policy change in 2015, but didn't hear back. Reporting live in Grand Rapids, Jacqueline Francis, News 8.